By Armistead M. Dobie. Testamentary Incorporation by Reference. The Doctrine. A will may, by proper reference to an existing paper, together with the expression of the testator's intention that such paper be made a part of the will, incorporate such paper into the will as an essential part of the will, even though the paper itself may lack the essential requisites of testamentary validity. The paper incorporated then derives a validity from the incorporating will and becomes to all legal intents and purposes a valid part of the will, controlling to the same extent as the will itself the disposition of the testator's property. This doctrine, certainly as old as the 18th century, is firmly embedded in the English probate law, and though repudiated in some states, has been very generally recognized with more or less favor throughout the United States. As will soon appear, there are numerous requisites for the successful application of the doctrine of incorporation by reference, as well as differences of opinion among the courts concerning these requisites. The skilled draftsman therefore seldom exposes his client's will to these extra hazards, which may easily be avoided by including in the will itself all expressions of testamentary intention. From a prospective viewpoint, then, the doctrine is undesirable, and resort to it is very seldom had by good lawyers, but only too frequently, alas for the will and those who claim under it. The lawyer is called in only after the death of the testator, when all that the lawyer can do is to make the best of mistakes which he cannot avoid or prevent. Incorporation by reference thus touches the lawyer's activities as a morbid anatomist of wills rather than as a draftsman. But so often does he serve in the former role, and so important are his tasks in that role, that the doctrine in question is of no small practical importance. 2. Requisites for the application of the doctrine. In spite of some statements to the contrary, 5 things must concur in order that the doctrine may be invoked. Of these, 3 things must be done by the will, while 2 things must be true of the instrument to be incorporated. The absence of any one of these 5 requisites, it matters not which, will prevent the application of the doctrine. 1. The will itself must (a) refer to the writing to be incorporated in such terms as to identify the writing with reasonable certainty. (b) Refer to the writing as one already made, that is, as an instrument actually in existence at the time of the execution of the will. (c) Show a clear intention on the part of the testator to incorporate the writing into the will, for the purpose of giving effect to the writing as an essential part of the will. 2. As to the writing to be incorporated, it must be shown (a) that this writing corresponds to the description of it in the will and is the instrument that the will seeks to incorporate. (b) That this writing was actually executed before the will and was therefore in existence at the time the will was made. Of these in their order: 1. (a) Identification of the instrument by the will. This requisite is of great practical importance. All that is required, though, is that the description in the will must serve to identify the writing with reasonable certainty. Since the writing, however, must, when produced, be shown to be the instrument referred to, the description in the will need not describe this instrument with such meticulous care and detail as to prevent any possibility of a mistake. Indeed, many of the descriptions held proper by the courts have been quite brief and couched in general terms. A few cases must serve to illustrate the considerations controlling the courts in deciding this question. The following descriptions or identifications in the will of the instrument to be incorporated have been held sufficient. Directions written in a book by Melvin W. Pierce, signed by me, Alexander DeWitt, and witnessed by said Melvin W. Pierce. The deed which I send you a copy of, when in the letter with the will, a copy of the deed was enclosed, a paper made and signed by me, labeled My Direction with regard to my school, a paper labeled My Direction with regard to my school, and bearing the signature of the testatrix, dated the day before the incorporating codicil, being found after testatrix's death. This is a codicil to my last will and testament. The will was invalid in itself for want of proper attestation. A will being found in possession of the testatrix at her death, in a sealed envelope containing an endorsement describing the instrument as the will of testatrix. And when after a diligent search no other instrument answering the description could be found, the word codicil was held sufficient to identify and incorporate a will written on the back of the same sheet of paper. A description of a deed giving the date and parties to the deed was held sufficient, and a similar holding was reached when a note was described by the parties and the amount. The following descriptions were held to be inadequate. A sealed letter which will be found with this will. The will provided that a legatee should have certain furniture, which she has got a list of, to C.H. Young, my husband, shall be handed to him. 2 deeds. I give such portions of my plate, etc., as shall be specified in a list which it is my intention to annex to or leave with this will. When a testator's death, the will was found in his strong box without any list, but such a list, dated 17 years before the will, was found lying loose in a drawer with others of his papers, reference to a codicil when a codicil was drafted by the solicitor but was never executed by the testator. 1b. Will must refer to the writing as already in existence. The will must, oh my goodness, seriously. The will must next reference, the will must next refer to the writing sought to be incorporated as already in existence. The description which the will gives of the writing must indicate in unambiguous terms, what is this? That at the time of the execution of the will, the writing, in the form in which it is to be incorporated, was then an existing instrument. If, therefore, this writing is described as one subsequently to be made, or if the description in the will leaves it doubtful whether the writing is a past or future instrument, there can be no incorporation. Even though the writing was actually executed before the will, this will not suffice unless the will so states. In the following cases, the reference in the will was held to be to the writing as an existing instrument. Directions written in a book by Melvin W. Pierce, signed by me, Alexander DeWitt. DeWitt? Is it DeWitt? I don't know. Probably. I'm getting jiggy with it, aren't I? and witnessed by said Melvin W. Pierce, a paper. Oh, jeez. I don't even know what that word is. Oh my God. And, and signed by me, labeled my direction, etc. Reference in a codicil, which presupposes a previous will to my last will and testament. In the following cases, the reference in the will has been held insufficient as not describing the writing as an existing document. Can't stop myself. Friends to be named in a letter. Reference to the instrument as made or to be made. Reference to such property as shall be ticketed or may be described in a paper in my own handwriting. Reference to a schedule hereafter named, such of my friends as I may designate in a book. Oh Lord, see, the yada yada must show a clear intention to incorporate the writing into the will. Lord, how did it get like this? Oh my God. This is of all the requisites, the most obvious. The law seeks to carry out the testamentary intentions of the testator and not to defeat them. The only warrant for incorporating a writing into a will is a clear expression in the will directing that this shall be done. Manifestly, in the absence of any expression of such an intent on the face of the will, there could be no incorporation of an instrument found ouch, with the will. As to the testator seeking to incorporate an instrument into his will, usually makes his intention clearly appear in the will. This requisite gives little difficulty in actual practice. Number 2A, the writing must be shown to correspond to the description of it contained in the, I guess that means well, oh my God, contained in the will, and to be there, or the instrument which the will seeks to incorporate. As to the instrument sought to be incorporated, the proponent of the writing must show that this answers the description in the will, and is therefore in fact the very instrument which the will seeks to incorporate. Parole testimony is freely admissible for this purpose, but such testimony cannot be given. Lord mercy, mercy, mercy. Please, Spirit. Oh my God, it won't fix it. Oh my God, I'm not gonna mess with it. So, given to identify the instrument when the testimony contradicts the description given in the will. Thus, in a leading American case, the will referred to. Directions written in a book by Melvin W. Pierce, signed by me, Alexander DeWitt, and witnessed by said Melvin. Yeah, it's a W. W. Pierce. When these directions are offered for probate, it could be shown by parole that they actually were written by Pierce and witnessed by him, and that the signature appended to these directions is that of Alexander DeWitt. But proponent of the directions could not incorporate them by showing that they were written and witnessed by John Smith and signed by Joseph Brown, but that still the testator intended the directions to be incorporated. To be, the writing must be, Lord have mercy, shown, that's shown. Okay, we can figure that one out. SHOWN. What was that other word? Maybe that's the same word. To have been actually, oh Lord, executed. Executed before the will. unless to have been in existence when the will was made. Not only must the will refer to the writing as an existing instrument, as we have seen under 1b, but this reference must be consistent with the facts. This statement in the will must be true as well as clear. If therefore, in spite of the statements in the will, the writing is then in existence, it can be shown that the writing was actually executed after the will was made, then there can be no incorporation, only past instruments can be incorporated by the will, not future writings. The law does not permit the testator by his will to reserve the right to incorporate into his will writings not executed with the required statutory formalities that he may make in the future. Even though the writing is executed immediately after the will, there can be no incorporation. There is no place here for the application of the doctrine, sometimes applied when testator signs the will immediately after the signing by the witnesses, that as between acts substantially contemporaneous, there is no priority. 3. Republication of will by codicil. It is a well-known doctrine of the law of wills that a will may be republished by a codicil, which brings the will down to the date of such codicil and makes the will speak as of the date of the codicil. What's this? All right, with such with such republication in general, we are not here concerned, but only with its effect upon the doctrine of incorporation. In this connection, only two of the requisites for incorporation need be discussed. Reference in the will to the writing as an existing instrument, and 2b, the writing must actually be in existence at the time of the execution of the will. As to 1b, the codicil usually has no effect at all, unless, as is rarely the case, the codicil refers to the writing, language of the will referring to such writing is in no way affected by the codicil. If therefore the will as originally executed validly refers to the writing as already in existence, such reference not affected by the codicil, which changed not the language of the will, but merely the date as of which the will speaks, continues valid as before. Requisite 1b, satisfied in the original will can remain satisfied on the republication of the will by the codicil. It also equally follows that if the reference in the original will invalidates incorporation because such reference is to a future writing not already in existence, then such reference its language equally unchanged by the codicil continues to be a future reference after the codicil, and there can be no incorporation. Yeah, like that. The unchanged future language continues to be future language. Requisite 2b. I don't know what that is. Requisite I don't know. The writing must actually be in existence at the time of existence. Oh, requisite 2b. I see what it is. The writing must actually be in existence at the time of the execution of the will, however, may be very vitally affected by the principle that the codicil makes the will speak and is equivalent to a re-execution of the will as of the date of the codicil. If the writing was in existence at the original execution of the will, necessarily it remains uh, a past instrument to the codicil executed after the will. Again, it is equally clear that if the writing was made not only after the will, but also after the codicil, the writing is future to the codicil as well as to the will, thus preventing incorporation. But if the will is executed, can we do that? No. After the will, but before the codicil, it is clear that such writing is future as to the will, but past as to the codicil. If, therefore, at the time of the will, every requisite for incorporation is present except to the existence of writing at time of will, now on the execution of the codicil, which makes the will speak as of the date of such codicil, the writing has in reality become an existing writing, and thus becomes incorporated by reference. This, the principles discussed in the two preceding paragraphs are admirably illustrated by three English cases. In regards goods of Truro, 1866, presented this situation. The will contained this reference. All such articles as are contained in the inventory signed by me are deposited herewith. The will was executed September 15th, 1865. The inventory was executed September 21st, 1865. The codicil to the will was executed October 10th, 1865. The inventory was thus non-existing when the will was executed, but was in existence at the time of the codicil. Sir J. P. Wilde held that the words of the will appear with sufficient distinctness to refer to a document then existing, and as the re-execution of the will by the codicil made the inventory writing actually in existence at the time of such codicil, the case was held a proper one for incorporation by reference, so that the inventory was admitted to probate together with the will and codicil. 2 years later, 1868, the same judge decided the case of in regards to goods of Reed. Here again the will was executed first. Later came the letter sought to be incorporated, and later still after the letter, a codicil was executed. Thus the writing sought to be incorporated. The letter again was not in existence at the time of the will, but it was in existence at the time of the codicil. So far, so good. But the will referred to friends to be named in a letter addressed to my two nieces. Language referring to the letter not as an existing writing, but as a future instrument. This future reference was not cured by the codicil, and there was no incorporation of the letter. Quite similar was in regards goods of Smart, 1902. Here the reference in the will was to such of my families as I may designate in a book or memorandum. The memorandum was executed after the will, but before the codicil. There was no incorporation. The opinion stating, if you treat the will according to the cases as speaking at the date of the codicil, the reference is still in terms to a document which even then is future, and therefore does not comply with one of the necessary conditions namely that it must refer to a document as existing at the date when the will is re-executed. For holographic wills, in many states, a will duly signed by the testator or testatrix is valid if properly attested by a certain number of witnesses, or is valid without any witnesses. If it is a holographic will, that is, if the will is wholly in the handwriting of a testator or testatrix, there seems to be no reason whatever why the doctrine of incorporation by reference may not apply as well to the holographic will as to the will that is duly witnessed. In the case of the duly witnessed will, the validity of which is safeguarded by the statutory attestation, the instrument to be incorporated may be written by the testator or another, or the instrument may be printed or typewritten, but in the case of the holographic will, which requires no attestation, the only safeguard against forgery and fraud, besides the testator's signature, is the requirement that the whole will in all of its parts must be in the handwriting of the testator. If the instrument to be incorporated, let's see, I'm going to go ahead and underline that. But in the case of the holographic will, there we go. Oh, there you go. I'm going to read that part again since I don't know where I left off. But in the case of the holographic will, which requires no attestation, the only safeguard against forgery and fraud besides the testator's signature is the requirement that the whole will in all of its parts must be in the handwriting of the testator. If the instrument to be incorporated in the holographic will is in the handwriting of the testator and all the requisites exist, then there is no difficulty about the incorporation of the instrument. But if, though all the other requisites for incorporation are present, the instrument sought to be incorporated is not wholly in the handwriting of the testator, does the doctrine of incorporation apply? The question. The question is not without difficulty. The case of, in regards, Plumell's estate seems to hold in favor of incorporation. In such a case, Gibson versus Gibson, without citing any authority on this point, declined to permit the incorporation of the non-holographic writing into the holographic will, Hughes versus Hughes also refused to permit the incorporation of the non-holographic writing. It is believed that the doctrine of the Hughes and Gibson cases is sound. To hold otherwise and to permit a brief holographic will to incorporate a lengthy non-holographic instrument would seem to be in the teeth of the sole legislative safeguard that serves to guarantee the validity of such a will. Quite similar to the Gibson case was the Kentucky case of Sharp versus Wallace, in which a similar conclusion was reached, that the holographic codicil could not incorporate the non-holographic will. 5. Signing will at the end. In many states, a will to be valid must be signed at the end of the will. This has given rise to an interesting question when reference is made before the signature to matter that follows the signature, usually on a subsequent sheet of the will or on the back of the sheet in which the reference is found. If such matter is read into the will at the point in the will which refers to such matter, then this matter is treated as preceding the signature and the will is validly signed at the end. But if this matter is not treated as incorporated into the will at the very point at which the incorporating reference is found, in other words, if the matter is still regarded only in the light of its actual physical situation after the signature, then of course the will cannot be regarded on this theory as signed at the end. This last is the New York view. The English courts and those of Pennsylvania hold, and this is believed to be sound, that the matter is incorporated into the will at the point at which it is referenced to, and the whole will is accordingly valid. 6. Incorporation by reference distinguished from use of extrinsic. It would be tricky here. Huh. Oh man. Cute. Nope. Here we go. Incorporation by reference distinguished from use of extrinsic documents to establish the testamentary trusts. But yeah, right. Okay, we'll just go all OCD all the way. The doctrine of incorporation by reference should be distinguished from the use of extrinsic documents other than the will itself, to establish a testamentary trust. If we're going to have big old spaces, let's have them. Any discussion of the latter topic is beyond the scope of this article. Mention of it is made here only to distinguish it from incorporation by reference and to show that the two are utterly different doctrines, controlled by different principles. Incorporation by reference tries to make the writing sought to be incorporated part of the will itself to be admitted to probate along with the will. Accordingly, when the doctrine of incorporation by reference is invoked, the question of whether the writing is or is not properly incorporated into the will, so as to entitle the writing to probate, is a question to be decided by the court of probate. A proceeding to create a trust in property against the person holding the legal title to such property in favor of another person by means of documents other than the will is an equitable proceeding, cognizable by a court of chancery. Even when such a suit is successful and the trust is created, the extrinsic document does not become a part of the will. Indeed, such suits are made necessary by virtue of the fact that the simpler and more direct proceeding of making the writing a part of the will could not be successful. The principles are well illustrated further. Oh my God. In the so-called trust ex maleficio, let us suppose that the testator wishes in his will to leave certain property to A in trust for the benefit of C, but that A persuades the testator to leave the property to A absolutely and unconditionally, A agreeing to carry out the trust as outlined in a definite writing upon the testator's death. It is clear that such writing cannot be incorporated into the will for the manifest reason that the will which gives the property outright to A Makes no mention of the writing, but if A is permitted under the will to take the property unconditionally for his own use and benefit, A will profit by his own wrong, and a manifest injustice will be wrought. This equity avoids by using the writing to create a trust in the property in A's hands by decreeing that A holds the property merely as a trustee for the benefit of C, the Sestake trust. 7. Admission of documentary evidence. Fudge. Fudge, 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 fudge. Oh my god. Admission of to what? To am in the construction of a will. To am. What is this? I don't know. Admission of documentary evidence to, we will figure it out, to blank in the construction of a will. A testamentary paper controls the disposition of the testator's property after his death. A writing incorporated into a will becomes, of course, a testamentary paper. After a will, though, is admitted to probate, the aid of a court is frequently sought to construe or interpret the will. Kitty, don't purr too loud. We're recording. In such a proceeding, to arrive at the intention of the testator as expressed in the will, documents or writings are frequently admitted as evidence to prove this intention. Oh, great, now I gotta use my right hand. Though such documents could not possibly, under the circumstances, be incorporated into the will by reference, these documents are not testamentary in character, for they do not in themselves dispose of the testator's property. The will does that. It's not all making sense. The will does that and is all controlling. The documents do not vary the will, nor do they attempt to add to the will or take from it. They merely explain it. Thus, the testator leaves all his property to be equally divided among his surviving, Lord of mercy, grandchildren. Documentary evidence not fulfilling the requisites for incorporation by reference might be admitted to show what persons are included in the class of surviving grandchildren. Again, testator might in his will bequeath to A the 3 horses bought by me from Bud Spilkins by Bud Spilkins. The bill of sale from Spilkins might be admitted in evidence to show which horses had been bought from him by the testator. In Hartwell versus Martin, testator who had made an assignment, here thereby securing legal discharge from liability for his then outstanding debts, attempted to provide by the will for certain of his former debtors, and the will contained the sentence: a list of all debts that I wish paid will be found enclosed with this will. The bequest to the debtors was held void on the ground that this list was not evidential, and that the testator was attempting to reserve the right to control the disposition of his property by a paper which the testator might change from day to day and thus enlarge or diminish his testamentary gifts. as often as he chose without observing the rules of law relating to the testamentary disposition of property. In Dennis versus Hall Supple, testatrix left all her property to whoever shall take care of me and maintain, nurse, clothe, and furnish me with medical treatment. At my request, the will further provided the person or persons whom shall be selected by me to earn my estate, as provided in fourth clause, shall have a written statement signed by me to that effect, to entitle her, him, or them to my estate. The court admitted to a letter to defendant signed by testatrix, indicating that the defendant was the person to satisfy the provisions of clause 4 of the will, upon the ground that the letter was evidential, as aiding the court to determine the person meant by the will, and was not testamentary in character. Lord, it's surprise, surprise ending. We made it. Thanks, everybody. Don't know if it made sense. Think it did. So the point is, every day you try to manage what you can to incorporate things as you can and complete when you can. But at least along the way, as you are putting things together, it helps. It helps to create a sense of order. Okay? So that's why we want to do this. We want to help create order. So, God bless you. Be well. There you go.